Dozens of homeless advocates laying in front of the Supreme Court of the United States today in Washington as justices heard arguments in City of Grants Pass versus Johnson. This is a landmark homelessness case out of Oregon, which could determine whether cities can fine or arrest people for sleeping in public spaces.
Nobody should have to be subject to intimidation, bullying, and live in fear of being punished because they don't have a home.
A lack of shelters in Grants Pass, Oregon, an appeals court there called the law cruel and unusual punishment. The U.S. Supreme Court expected to hand down their ruling at the end of June.
L.A. City Attorney Hydee Feldstein-Soto has filed 2 amicus briefs with the court in this landmark homeless case, seeking some clarity on regulations of shared public spaces. And the city attorney, madam, she joins us now with more. Good to see you. Thank you so much. In the simplest terms, what is at stake in this case, and what are you seeking in terms of a clarification?
There's 2 issues. The first one is we do not oppose the basic ruling that the 8th Amendment prohibition on cruel and unusual punishment prohibits carceral consequences, arrest, criminal justice for simply sleeping in public when you have no place else to go. The flip side of that is that the Ninth Circuit opinion has language that is significantly, potentially broader than that. And so what we are seeking is clarification on what can we do. Los Angeles has for more than a decade hewed a path between balancing the rights and privileges of the housed with the unhoused, not criminalizing homelessness, enacting compassionate laws, but at the same time protecting our most sensitive areas around places like schools and balancing the needs of the housed and the unhoused around the city. So we filed a brief seeking clarification of time, place, and manner regulations, not criminalization of homelessness.
So basically, does this come down to this? Say there is an encampment near a school. You all want to clear that out, move those people hopefully inside, safe, or just frankly away from the school. If you do that right now, somebody could sue you saying, we don't know about the Ninth Circuit, and you've got to spend all this time and money on the lawsuit instead of spending the time trying to make the people safer. And so you could, if this comes down, basically say, look, this case is settled, throw it out of court. Is that basically what this is all about?
To some extent, yes. We're looking for the fact that ultimately policy on what is a rational basis and how do you balance these circumstances on a case-by-case basis. There might be an encampment where there is criminal activity. There might be an encampment where there is sufficient risk to public health that it needs to be cleared. As long as we have a place for everybody who's there and we offer them the place, there isn't anything in our laws that would permit us to simply go out and arrest. I would point out that we were joined in our position by the governor and the attorney general of the state of California, by the county of Los Angeles, by the city and county of San Francisco, and by a coalition of a number of cities across California. In fact, the Deputy Solicitor General of the United States, who argued the case this morning, was making arguments that were very closely aligned with the position of the city of LA.
Now, the ACLU takes a stance that this is punishing people, that criminalizing people does not improve public safety. But you're not saying that. You're not saying that we want to criminalize people. We just want the ability to move them away from these shared public spaces.
Or bring them inside, okay? Or conduct a cleanup where it has become a public health hazard, or establish safe zones. For example, our streets where traffic goes back and forth, our car lanes and our bike lanes, are public spaces. Surely we can regulate that and prohibit camping there. Around our schools, we've established a buffer zone. 4118, and I understand it is controversial in Los Angeles in many quarters, but I will also tell you that it is a really good balance in terms of constitutionality and regulating our public areas.
So real briefly, you heard the arguments today, and based off of the different questions that justices brought up, you get a sense of where they're at. Do you think you have the votes?
I'm cautiously optimistic that the court will come down as we argued. I believe that there are at least 3 solid votes against criminalizing homelessness, and that is an important principle. There are 3 others that are at least maybe on that issue, and 3 that probably would not analyze the situation under the 8th Amendment. With respect to time, place, and manner regulations, all the justices seemed interested in that issue. So I am hopeful that cities will be given some leeway and some deference.
So which conservative justices are you pulling for?
I don't want to jinx myself.
Okay.
All right. Well, we expect that ruling at the end of June. We appreciate you.
Unusual coalition you see on this one.
Yeah.
I'm hopeful for everybody that they see the light of day. How's that?
Okay. Los Angeles City Attorney
Thank you very
Hydee
much.
Feldstein-Soto. Thank you.